Next motion.
This is for, Your Honor, this is for mandatory joinder and merger of counts. I'll leave aside the mandatory joinder discussion. I think that's one where the state has no opposition to these counts being tried together, these counts in each indictment. Rather, the critical issue, Your Honor, what we probably have an argument about is merger. And I would submit that what I'm arguing to the court today is that the state already, it's already established that there is no intervening event as defined by statute.
How do you, excuse me for interrupting you.
Yes, sir.
You keep referring to the fact that the state has already established and the state cannot prove an intervening act. Tell me how you know, since we haven't put on a single witness in trial, yes, how do you contend as an officer of the court that the state is simply not going to be able to do that?
Yes, sir. I look at the statute, which provides the 3 ways that a single course of conduct can be separated, of stalking, alleged stalking, can be separated into multiple courses of conduct. And it's defined by the statute at TCA 3917-315K. K1 says that for purposes of determining if a course of conduct amounting to stalking is a single offense or multiple offenses, the occurrence of any of the following events breaks the continuous course of conduct with respect to the same victim that constitutes the offense. Those 3 events are: the defendant is arrested and charged with stalking, aggravated stalking, or especially aggravated stalking. That is not alleged in this case.
Where are you reading? What?
Yes, sir. 3917-315.
Okay.
And that this appears in my motion for mandatory joinder and merger.
Right.
So that event we know is not alleged by the state and hasn't occurred. If the state says it has occurred, that would be new information. It doesn't appear in the discovery. I will say in candor to the court, the defendant was, I believe a warrant was taken out after the August 1 allegations. And so a warrant may have came out August 2, but he was not arrested on that, Your Honor. And that means that circumstance A is not fulfilled here. So there is no intervening event based on A. Then B, another one would be the defendant is found by a court of competent jurisdiction to have violated an order of protection issued to prohibit the defendant from engaging in the conduct of stalking. That has not happened. There are no signs that it has happened. And finally, the defendant, this is the 3rd intervening event, the defendant is convicted of the offense of stalking, aggravated stalking, or especially aggravated stalking. So that is not alleged to have occurred. All 3 of these have this commonality of they are procedural in nature. They have to do with the criminal justice or civil order protection process. And it's clear already that none of them occurred. That's why the court can move on to merge these counts, because as a matter of law, the state will not be able to prove an intervening event. So therefore, it ends up being 1 count of stalking of some kind. That's what it ultimately ends up as. The court can already get to that. And these rules make sense, Your Honor. They're there so somebody who's accused of stalking on one occasion, who's then arrested for that stalking charge, and then continues to stalk somebody, can still have another charge placed against them. So there's a good reason for these rules to be the way they are. And in this case, none of these situations have occurred. Rather, it's much more like Mr. Sheets is accused of stalking in a single course of conduct over 2 days, and it's just going to be 1 charge. We can already say that. And that's why I asked the court to do that. There's also some law here. In one of the cases cited by the state, in one of the cases cited by the state, the State versus Vigil case, in their response, this supports the defendant's position, because in that case, there was a defendant who was charged with, convicted at trial of 2 counts of stalking, and the Court of Criminal Appeals found that the actions of the defendant for which he was convicted in the first count of stalking had occurred from February 1996 to January 1997, over a year. And then in the second count, he was convicted of stalking for events occurring February 18, 1997, March 17, 1997. And the Court of Criminal Appeals said that all of those are 1 continuous course of conduct with no intervening event. Therefore, it was a violation of double jeopardy for the defendant to be convicted on the first count for the conduct that occurred, to be convicted separately on the first count for the conduct that occurred February 96 to January 97. So here it's a similar situation, except the time frame is much shorter. Here we have what, according to the information provided by the state and all information available to the defense, this is a single course of conduct that Mr. Sheets is accused of. So we can go ahead and say this is not 2 counts. To charge him with 2 counts over this based solely in the discretion of the state is multiplying the counts unnecessarily and in violation of double jeopardy given the way that the statute is formulated. I'll leave it at that. Oh, no, there's one more thing. The state's response said something about something emphasizing the knowledge of the defendant as far as whether he can be charged with an additional separate count of stalking. That's not relevant. That's not the criteria for whether the course of conduct is broken into 2 separate courses of conduct that would amount to 2 separate charges.
Your Honor, effectively what the defense has done is he's asked you to dismiss one of my cases. He's filed a motion to dismiss.
What he's actually asking me to do is to grant what would be in the civil terms as a motion for summary judgment.
Correct.
In other words, that at this stage of the game, there's not enough evidence to, warrant the plaintiffs in a civil case being able to proceed, so therefore you ought to dismiss it as I'm entitled to judgment as a matter of law.
Yes.
That's the way I'm interpreting it.
That's the way I'm interpreting as well. I have a 1-count indictment. They're asking to have consolidated and merged, which is you're asking to dismiss my case outright without hearing any proof or allowing a jury to decide if I haven't met my burden. So that's mainly where we get with the motion for merger and consolidation for trial. Now, the law does state that there is to be an intervening act, which it says the initiation of process and criminal charges. And we do have that. And like he said, it is not relevant to whether or not the individual knew it. The warrant was sworn out on August 3rd, and there was additional contacts made after that, after he had been seen by law enforcement. I can, one of the deputies is available to testify about that knowledge that was shared. That is all in the discovery. They know exactly when all those dates are, but the law does say that to start and stop a course of conduct, the initiation of criminal charges, whether the defendant is aware of them or not, can be the intervening thing to separate into 2 different cases. Right now, or 2 different charges. Right now, we have them as 2 separate cases. And in my response, it does say, if they want to waive and consolidate them and do 2 counts in 1 trial, there's going to be a huge prejudice to the defendant that should we go forward, should a jury say, you don't have enough to meet that 2nd case, they very well could use information on count 1 into count 2. But if the defense wants to consolidate those for trial and run that risk, that's on them, and I will not oppose that. But I do say that there needs to be 2 separate counts and that there is an intervening act. And they are very well aware of that through discovery, and it does meet the law and the requirement to separate into 2 counts.
I'm going to rely on the statute, which says not that the initiation of criminal process breaks up the course of conduct, but that the defendant is arrested and charged with stalking, aggravated stalking, or especially aggravated stalking. And there's no arrest. The state doesn't say that there was an intervening arrest. So I'll leave it at that.
That hearing had a little bit of everything. Judge David Wolfe presided over a motion hearing that dove deep into the weeds of statutory language and double jeopardy. And it was a sharp reminder of how technical pretrial arguments can shape a case before a jury ever hears it. The defense pushed hard for merger of 2 stalking counts, arguing that the state's own filings showed no intervening event that would break a single course of conduct into 2 separate offenses. Counsel walked through the statute, 3 possible intervening events: arrest, violation of a protective order, or a prior conviction, and argued none had occurred here. To the defense, this was one continuous course of conduct, and charging 2 counts was multiplying the case unfairly and potentially violating double jeopardy. Judge Wolfe pressed the defense on how they could know, before trial, what the state might prove, reminding them that calling something, already established, without witnesses was essentially asking for a summary judgment before evidence was heard. The prosecution countered by pointing out that a warrant had been sworn on August 3rd, and contacts continued after that. Under their reading, the initiation of criminal process itself could count as the intervening act needed to split the conduct into separate counts. They also raised the strategic issue. Consolidating counts might let otherwise inadmissible evidence bleed across, prejudicing the defendant at trial. The debate showcased 2 very different readings of the same statute, defense leaning on a strict textual interpretation, prosecution on a more practical process-based view. Judge Wolfe listened carefully, weighing both sides without rushing to decide, but he was clear about the stakes. One side was essentially asking him to dismiss a case outright before a jury saw any proof, while the other was intent on preserving 2 counts as separately viable. The atmosphere was calm but intense, the kind of hearing where each word of statutory interpretation mattered more than any emotional appeal. It was less about theatrics and more about laying the groundwork for how the trial would even be framed. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.